Good afternoon, everyone. Good morning, everyone. I welcome you to this last session of the Construction Symposium, which Mason has organized. And I welcome you all to this last session, which is maybe the last, but a very, very important session. And that's the reason we thought that we'll keep it in the last, because the ending always has to be the best. So the session is about the most common dispute which we come across in construction: liquidated damages, delay, prolongation, disruption, idling, etc., etc. In my experience of more than 25 years in construction industry and having appeared as expert in number of arbitrations, I have not come across, a dispute where delay and prolongations are not the matters of dispute. So, in this session, we are going to discuss along with the specialists and experts, both from industry, law, Indian law, and international law, how to handle delay and how to handle delay related damages and claims. So before proceeding, let me introduce the panelists. I have with me Mrs. Rashmi Kathpalia. She is Senior Vice President Legal of Technip India. Technip is one of the strongest and top EPC contractors in the oil and gas. Rashmi is Senior Vice President for Technip, a multinational group company of Technip Energies, and heads its legal department. Before Technip, Rashmi was legal head for a US subsidiary in the same field of EPC and infrastructure investments for nearly 2 decades. Prior to her in-house legal head roles, Rashmi was a litigator with an active court practice for over 10 years. She received the Trailblazers Excellence Award Energy Sector in 2019 from the Indian Corporate Council Association, and in 2018 was recognized by Legal 500 UK in the GC Power List India, among several other recognitions and awards to her credit over the long span of her career. She is one of the very few women lawyers with specialization in EPC contract, more specifically in the energy sector, and has current hands-on knowledge of PSU terms of construction contract. So she will provide us the construction contractor's perspective on the issues under discussion today. Thank you, Rashmi, for joining us. Then we have got Mr. Ratan Singh, who is a senior advocate. He is chairman of Society of Construction Law, India chapter. He is also director of Chartered Institute of Arbitrators UK, India chapter. Mr. Ratan Singh is a senior advocate and arbitrator based in New Delhi, having 25 years of experience with specialities in construction, engineering, infrastructure, mining, commercial, and civil dispute. He has received numerous arbitral appointments as chair, wing arbitrator, and has represented parties in complex, high-value domestic and international arbitrations under major arbitration rules. He has also been involved with the industry players and stakeholders through chairmanship of the Society of Construction Law India and directorship of CIARB India. Welcome, Mr. Ratan Singh. Then we have got Mr. David Brown, who is partner of Clyde & Co. France. David Brown, partner at Clyde & Co. has wide range of experience of international construction and dispute resolution matters. His dispute resolution experience notably involves international arbitration as both counsel and arbitrator concerning a broad range of commercial matters in addition to construction. He features on the FIDIC President list of adjudicators as well as FIDIC French national list. In fact, David has been involved in number of Indian related arbitrations, also international arbitrations, and I welcome David on this session. My name is Rohit Singhal. I am the CEO of Mason, and I appear as technical expert, both delay and quantum, in international and domestic arbitrations. So without taking much time, let me now jump to the topic delay. So Rashmi, let me start this session with you. You are going to bring an industry perspective to this session. And, Technip, as I said, is one of the renowned companies in the oil and gas EPC sectors in India. So as a renowned international EPC contractor, what are the typical contract terms that you find are overly burdensome or make you not to participate in a bid? Over to you, Rashmi.
Thank you, Rohit. Well, in the infrastructure industry, projects are usually awarded by the tendering system, as most of us know, and they're based on certain financial criteria. So the lowest bidder, L1, is allowed to work. And with the PSUs, these contracts are usually non-negotiable. and bidders are not permitted any material deviation from the fixed contractual terms and conditions. Any unilateral change by the bidder results in the bid being rejected, and this allows the owner to impose certain contractual terms and conditions that are unbalanced and tilt the contract in favor of the owner. So terms of a construction contract mostly revolve around time and cost, and this becomes a challenge for the contractor, not being compensated for the delay, like you mentioned, which is our topic today, really the prime topic. And we have to choose between accepting unfavorable contractual terms or give a no-go to the business teams against bidding for the work. So some of the examples that I would like to share with you are things like uncapped liabilities. Overall liability cap of a contractor should not exceed total contract value under any circumstances, and only certain standard exclusions should be there in the total liability cap, such as infringement of IP, willful or deliberate misconduct, and gross negligence. More and more owners we've seen and PSUs provide a liability cap, which is just notional with so many exclusions that the capping provision is of no protection to the contractor at all. And these may be liability arising from termination of contract or liability when the owner is unable to take the possession of the plant, etc. So these uncapped liabilities become very challenging for us. Then there is, indirect or consequential damages when these are not excluded, because we need a well-worded indirect liabilities exclusion from our terms and conditions. Another one would be when there is unilateral right of the owner to terminate without cause, and especially where compensation for such termination is very limited. Another onerous term is unilateral right of the owner to terminate without cause, especially where compensation for such termination is limited. Then, of course, if there is liquidated damages, which are not the sole remedy and they are not capped, that becomes burdensome. If there's no variation clause, this would be a very big no-no. If there's no flexibility for extension of time and cost impacts, there's no change clause, how do we really perform? It becomes very cumbersome for us. If there is no proper end date and there is no end of defect liability period for us, that is a problem. Then there are certain no-go provisions specific to the oil and gas industry. There are performance guarantees which are required to be given by the licensor. And if the contractor is not the licensor, and the EPC contractor, the owner wants the EPC contractor to take on the responsibility, then we are unable to take that into our EPC contract value. And so this is a entire deficiency in that process. Licensing becomes our responsibility, which we do not want to take. We only want to be responsible for the mechanical or the workmanship guarantees. Another very onerous term that we are coming across repeatedly is the rely upon information. Now, the client gives us a package of information and expects us to reconfirm everything that is there. And if there is any latent shortcoming which emerges out of this, it leads to negative impact on the schedule and cost. And of course, our resources have to be used to overcome unknown conditions later on. And if we are going to do the entire information confirmation, that is an additional cost in itself. So more and more, we would like the owners to give us detailed feasibility reports, which is completely rely upon information, and we don't have to go into it all over again. Another very important issue is, impracticable timelines, which we are seeing especially with our PSUs. We see the timeline that they envisage is almost 3/4 of the time actually required. So in the end, it will lead to extension of time or prolongation. Another very big requirement of very recent times is the elephant in the room, which no client wants to address, is the COVID impact. We have force majeure clauses which allow us extension of time. But now we know that there is a cost impact to this, and Indian courts have clarified that these costs will be payable if the contract allows. But in none of our contracts, clients are agreeing to, even the ones that we are negotiating right now. And we have clients whose active projects are going on and they know the impact, but for the new projects, they do not want to address the cost impact on the contractor at all. And this is a very variable cost and it cannot really be incorporated into our pricing. Another issue that is coming very often is that permits and approvals or handover of site is not it does not become a topic of cost implementation and even extension of time, and our personnel are waiting already engaged to be put. So rarely these provisions we are seeing in EPC contracts are being allowed as changes. For example, towards the end, there's commissioning going on and there is no feed for the PGTR. And our personnel are waiting on the site, and at the end, the owner does not want to give us remobbing costs at all, or wants to carry on with the care and custody of the plant without really extending its coverage. So all these are very burdensome no-go clauses for us, but the no-go is really the last remedy. And how many tenders will you not bid if you're really in the market? So at the bid stage, we have to carry out a thorough risk mitigation exercise, taking into account the scope of work, conjunction with terms and conditions, circumvent the onerous ones, robustly do our technical and practical solutions, and preempt really the outcomes and analyze the impacts. So I would say that how we execute projects despite burdensome provisions and circumvent them through our execution mitigation is the only way to perform at present. But I don't think it's going to last long because competition is stiff, and in this stiff competition, the owner will not be able to dictate the onerous terms simply because the owners now more and more realize that allowing for the extension and costs is there is a better way of contracting rather than leaving situations vague and resolving on expensive dispute resolution. And with all this increase in competition, there's also a lobbying going on with the owners. So terms and conditions are really not favorable for the contractor at present. And like I said, they may be burdensome, but we have to circumvent them somehow. In some, the laws are supportive of us, and we have our very able experts today to expound on that. I can tell you that from the industry perspective, from the contractor perspective, our only fallback and safeguard currently is our execution teams more than our contractual terms.
Thank you, Rashmi, and I fully agree and appreciate your position as a EPC contractor. In fact, in my experience of having appeared in so many disputes related to delay, whatever you said, whether it is the rely upon information, the permit issues, the liability exclusion clauses and the capped on the liability, liquidated damages not being defined properly are issues which ultimately get in the parties, both the employer and the contractor, into dispute. As a matter of fact, internationally, especially in the oil and gas industry, I do see that a lot of open book concepts are coming in, where a contractor is front end design is done by a particular contractor, and the same contractor then takes forward the execution on a kind of a fair and transparent method rather than open tendering method. But thank you, Rashmi, for your great comments. Now moving to you, David. We have seen the industry perspective from Technip, and which is an international EPC company. Now moving to you, what as per you is the different approaches on delay damages under common law and civil law? You practice both. You are in France, which is a civil law country. You also have practiced international construction arbitrations under common law. So what, as per you, is the difference and how these matters are dealt under the standard forms of contract? So I have two questions for you, and over to you, David. Thank you.
Thank you very much, Rohit, and thank you for allowing me to participate in this very interesting session. Very interesting listening to what Rashmi was saying about the importance of getting decent drafting and trying to get the drafting right. I'm going to focus on the foundations a little bit more in this answer, the underlying law, which to some extent means that the drafting can't alter certain things because there are certain things in the law that are mandatory. I practice, as you said, both as an English solicitor and as a French avocat. Hope you'd excuse me if I focus a little bit on English and French law in this answer, but I think this is justified anyway, given the central position of English and French law in the civil law and common law systems. And they have a huge influence when it comes to international construction contracts. So I think it's fair to say that the subject of delay damages, liquidated damages, is one where significant differences remain between the two systems, common law and civil law. And if there's one issue it is to be discussed, it is whether this delay damages provision is actually a penalty clause. Now, at the risk of oversimplifying, civil law systems, in these systems, the idea of penalizing a party for delayed performance is not only valid, but standard in common law, in construction contracts. But in many common law systems and in English law, any provision that is considered to penalize a party will be unenforceable, even if the parties expressly agree to it. So we have a bit of a big difference. So the big difference between two countries, each side of a very narrow stretch of water, the Channel. The French law position goes all the way back to the introduction of the Civil Code in 1804, very much inspired by Napoleon. And the key wording, which is now in Article 1231 of the Civil Code, has hardly changed since then. If I just quote it, where a contract stipulates that the person who fails to perform shall pay a certain sum of money by way of damages, the other party may be awarded neither a higher nor a lower sum. Very simple. And that has always been understood to allow for penalties. However, 40 or so years ago, the legislator decided to modify that a bit to allow the courts to reduce or even increase the penalty in cases where it was considered to be obviously excessive or derisory. I understand that was a bit of a reaction to the shock going through the industries, a lot of insolvencies as regarded the first petrol crisis in the mid-70s. What the Civil Code also says is that parties cannot modify these provisions. You are stuck with them. And I'm aware that other civil codes, the German and Chinese codes, have similar provisions. And I'm looking forward to hearing what I think Mr. Singh may be saying about Indian law in a few minutes, if we get onto this. So, other side of the Channel, what's the position under English law? Well, the English law courts, the English courts have had an aversion to penalties that goes back at least to the 16th century. These are very deep-rooted positions in the law. And throughout the 20th century, the consistent view was that a delayed damages clause not only had to be free of any hint of a penalty, but also had to show that there was a real effort by the parties to evaluate what the likely losses would be in the event of a breach. So the key concern of the courts, until quite recently, was proof that there was a genuine pre-estimate of loss. So unlike the French approach, in France, it's been the legislator who has been laying down the law. In England, it's always been the courts. In the 20th century, it was the House of Lords that laid down this position in 1915. Then exactly 100 years later, the successor to the House of Lords, the Supreme Court, revised the law in what's known as the Cavendish Judgment of 4th of November 2015. It decided that the requirement of a genuine pre-estimate of loss was no longer essential. So instead, the key test is now, just to quote, whether the sum or remedy is exorbitant or unconscionable when regard is had to the innocent party's interest in the performance of the contract. So what we have here, in a sense, is a move towards the French law position, you might say. In other words, the damages must not be grossly excessive, but a fundamental difference remains. Under English law, if the test is not satisfied, the clause will be considered a penalty clause and struck out completely. There is no question in the English system of modifying its application. That is something that English law has difficulty with. So we have two fundamentally different approaches. So how does this play out in standard form contracts, where the draftsmen generally are trying to produce a product which is viable around the world? Well, first of all, what must be said is that there are unfortunately hardly any civil law-based standard forms used in the international construction world. The only one I know is a World Bank form for civil works, published about 15 years ago, that is specifically for civil law countries and has a very typical French-style penalty clause. No reference to liquidated damages at all. In fact, the contract doesn't even exist in English, which is unfortunate. Otherwise, what do we have? Well, we have FIDIC, we have other World Bank forms, we have NEC, for example. They dominate, and they, I think as everybody might recognize, are heavily common law in inspiration, if not always in content. So what you tend to find in these clauses is that the wording of the delayed damages provisions try to avoid the trap of getting too close to either the common law position or the civil law position. However, this does not mean that their application will not be problematic. The fact remains that if the applicable law is, for example, French law, or the law contains similar provisions to the French penalty provisions, then it is not simply necessarily valid just to deduct liquidated or delayed damages in the normal way, because that might be a penalty which is excessive and which the court, the arbitrators, may want to reduce. And I'm glad to say we've been able to do this for clients. So you've got to be very careful in the application of these. The underlying law is always important. Thanks, Rohit.
Thank you, David. Thank you for setting out the stage for discussion on the legal issues of delay. Now here at this stage, Mr. Singh, I'll move to you. So please enlighten us how Indian law deals with delay damages.
Thank you, Rohit, and good afternoon, everybody. Thank you, Rohit, for having me in this panel. David dealt with liquidated damages position under English law and French and under civil law jurisdictions. I'll deal with this in a while, but before that, let me go ahead with the broader issue. Delay and disruptions are essentially basically like pandemic to the construction industry, and so is the delay and prolongation claims. I wanted to share my thoughts on some basics, then we can move on to the LD situation, which is another very important aspect. Invariably, and again, I have been asked to talk about Indian position. Invariably, what we see in India is that whenever you have delayed damages which are being led, the distinction between delay and prolongation is not appreciated. We all know delay means delay on the critical path of the schedule, or it's a delay of critical milestone or critical activity. And delay should really delay the completion of the project, unlike prolongation. And therefore, whenever there are delay claims or prolongation claims, it is essentially and can be defined as a claim for losses suffered due to compensable delays. Losses suffered due to compensable delays. So delays should be compensable. And what is compensable delay is again something which we all should keep in mind. Compensable delays are the events that gives rise to entitlement to extension of time and related cost. Unless you fall under this situation, you do not have prolongation claim in real sense and theoretically. In India, I would say that the typical prolongation claims are those claims which are allowed globally. So here in terms of heads of claims, you will not find difference in the India. So the typical the prolongation claims are site overheads and establishment cost. So you have a staff, you have labor cost, you have plant and equipment, machineries, hiring charges, office charges. So these are basically site overheads and establishment cost. And these are routinely allowed. You don't need judgments in support of this. Every judgment would talk about this. Another prolongation claim is head office overhead. So we talked about site office overhead. Now we are talking about head office overhead. And because of this, the peculiarity of head office overhead and because of the fact that there are certain guesswork in this. And, so you have certain formulas which are globally applied. In fact, Indian law, and we have judgments to this effect, which recognizes the use of leading overhead formulas like Hudson, like Emden or Esley. And the authority on this can be said to be McDermott International Judgment of Supreme Court. That was 2006 judgment, and which is 2006 volume 11, SCC 181, if anybody wants to take note of it. And then this judgment has been followed in multiple judgments of Supreme Court and otherwise other judgments. However, use of formula alone is not sufficient. And this is where one should be very, very careful. The contractor must produce some evidentiary material to justify its calculation using the formula. And for that, if anybody wants to write a judgment, one judgment is Indo-Nabeen Projects versus Power Grid Corporation, India. This is Delhi High Court judgment. Another judgment is SR Procurement Services Limited versus Paramount Bombay High Court judgment, which is 2012 judgment. So this is typical of head office overheads. One should end. Closely associated with this head office overheads is the claim for loss of profit earning capacity or loss of opportunity. And it is clubbed. Both of these are clubbed, though strictly speaking, it would be two separate heads, but for convenience, it is clubbed because end of the day, it is dealing with head office situations because head office could not involve itself in earning. And but again, for the delayed period, if head office would have been available to take other works, so then that opportunity has gone. But the victim of such opportunity must be proved, and also the likely profit which would have been earned under such an opportunity. You cannot simply say that project got delayed and as a result of which I could not deploy my resources for other tenders. What were those tenders? Whether you were eligible for that and so on and so forth. In fact, two judgments I can refer. HAI versus Hindustan Construction, which says that victim of such opportunity must be proved. So one is NHAI versus Hindustan Construction. This is Delhi High Court judgment. Another judgment is Bharat Coking Coal versus LK Ahuja. This is Supreme Court judgment of 2004. Though English law position is slightly lenient and the standard of proof is lower, but I have been asked to talk about Indian law position on this. So apart from head office, the site overhead and establishment, we also discussed about the head office overhead. Another category of claim is financing charges, and which is found to be payable under Indian law. However, they must be substantiated and proved. What is this financing charges? Financing charges are the cost which is incurred by the contractor for the capital which is used in the project and for which they have they are incurring cost in terms of interest and so on and so forth. If it is external borrowing, then the kind of interest you pay, you have to prove that. If it is a self-finance, then again, what interest you could have earned on that amount, that capital, is something which you have to look at. And one judgment for this, that which allows financing charges, is NHAI versus HCC. This is 2016 SCC Online Delhi 1144. There. And another category, I would say, though not very frequently used in India, is acceleration claims. However, wherever acceleration claim is requested to make up for the delay, costs incurred for acceleration are compensable. And one judgment one can note, that is National Thermal Power Corporation versus Siemens. This is Delhi High Court 2012 judgment. Now, one thing which I would like to say my thought on is, whenever you are claiming prolongation claim, one should be conscious of the fact that all delays are not compensable, as I said earlier also. Secondly, now, what if you had float available? Are you really giving allowance for that? What if there is concurrency, that is the delay done by both the employer and the contractor? Or do you take care of that? Obviously, concurrency is a much more complex issue, and that can be dealt with in later. But you have to take into consideration how to deal with neutral events which are not attributable to either of the parties, how to deal with that. So these are, and again, there are certain typical Indian contractual provisions. I would not say typical Indian. There's a lot of forms, a lot of situations in many other jurisdictions, where in certain situations, contractor is held to be entitled for extension of time, but not for damages. And in India, such clauses are found to be enforceable. And Ramnath International is the classic case, which is followed in ONGC versus Weak Brothers by Supreme Court. And then you have multiple Delhi High Court judgments, which accepts this position, which says that, and I have dealt with situations where the contract, there's a contractual stipulation which says that howsoever delay employer may have caused, contractor would only be entitled to the extension of time and not any delay damages, and these are held to be enforceable, contractual provisions. One last thing on this is, there is one interesting judgment of Calcutta High Court, which said that prolongation claims must be supported by contemporaneous records, if that is the requirement of the contract between the parties, which generally you find in the FIDI contracts. And this judgment is, and on that ground, because the contemporaneous records were not available and the arbitrator had allowed the claim, the courts had set aside the award. This judgment is a state of West Bengal versus FCONs. So this is one interesting judgment, 2013 SCC Online, Calcutta 16533. So this is one aspect, and if time permits, I can straight away go on to liquidated damages, or if Rohit wants me to stop here, I'll stop and cover it later.
Yeah, so Mr. Singh, we'll come to the liquidated damages, in our next question, in our next round of discussion. So thank you. You have really correctly put forward the Indian position. Now, what Mr. Singh said was 2-3 very important points. Number one, it's a very big industry misnomer that if an extension of time is given, let's say for 100 days, then entire 100 days prolongation cost is to be given to the contractor. No. The concept of excusable delay and compensable delay is very important for contractors and employers to understand. An excusable delay is a delay which allows an extension of time without liquidated damages, while a compensable delay is a delay which allows extension of time plus extra cost to the contractor. So this concept is very important. The other important concept which Mr. Singh laid down was the critical delay. In a typical construction dispute, what happens is employer says, contractor, you have delayed, contractor says, employer, you have delayed, and there is always a dispute. But not every delay is a delay which entitles a contractor to an extension of time and also the employer to liquidated damages. These are those critical delays, which the wording or the definition of critical delays, a delay which affects the end date of the project, or a delay which has got minimal float, zero float, right, kind of thing, is a critical delay. And of course, critical delay concept is a very, very extensive theory which is there, which we as delay experts come and testify in front of the tribunals to make them understand. So in order for any contractor to raise a prolongation cost claim and an extension of time claim, what is most important is first to establish that the delays which are being pleaded or being alleged to be caused by the employer are critical to the project, or they are coming under the category of critical delays. Otherwise, if you say that any delay is a critical delay and has given an entitlement to the contractor for extension of time, no, that's not the case. I'll give you an example. If you have got a house to be constructed and the roof of that house is delayed by the employer, and parallelly there is a small window which is being delayed by the contractor, the critical concept of the delay will say that the roof is critical at that stage and not the window, and which is a small work which can be taken up very easily. So at this stage now I move to the next point, which is to you, Rashmi. When you put up your claims for extension of time or your applications for extension of time and additional cost, what has been your experience? How does PSUs, which you deal with, deals with such kind of extension of claim submissions?
So Rohit, regarding extension of time, my experience has been mixed with the oil and gas PSUs. Even with proper justifications and analysis of the delays in owners' obligations, for example, even force majeure, we've had limited success in getting the time extensions. The major issue in time extension cases, particularly in PSU scenario, is that we have to wait till the completion of the project, and in some cases till the delivery date for the owner to approve our time extensions, to even consider those time extensions. And so till the owner approves the extension of time, payments are withheld, and bank guarantees need to be extended, and the project gets into a cash flow crunch, which makes it very difficult for the owner to sustain itself during such situations. And also, once the project is in operation, owners' priorities change, and it is no longer under pressure to have a functional plant. And so conclusion of our EOT requests and claims keep getting delayed, and we would like PSUs to have some time limit placed in which they release our payments and allow some quick ADR short periods, so that there is no financial crunch really faced by the contractor. So extension of time right at the end really doesn't work for projects. It has to be on an ongoing basis throughout, and it's the norm really in India that any EOT that you're asking for will be assessed towards the end of the project.
Yeah. So I fully agree. Rashmi, what you said is absolutely right. The concept is, typical position which is taken by a lot of employers is let's review EOT at the end, or they may grant a provisional extension of time with their right for liquidated damages and all. But yes, always it is better that that the issues be tackled then and there. If an extension time has to be given or prolongation cost has to be given, it should be given contemporaneously so that the contractor, is benefited by such kind of extension of time. So thank you, Rashmi, for that input. Now moving to you, David. There are a lot of issues related to the fact that a lot of extension of time applications or delay submissions by the contractors are rejected because they are considered to be time barred. A typical contract clause in FEDEC and in other contract conditions says that whenever a contractor encounters a delay, the contractor has to submit an application for an extension of time, explaining the details, and probably within 7 days, and then later on within 28 days, provide the entire submission details related to extra cost, extra time, and all that. Now, how good are such time barred clauses when in civil and common law, as per your experience?
Thanks, Rohit. Yes, this is something that seems to really come in the last 20 or so years, and to some extent, FIDIC bears the responsibility. They introduced the 28-day notice provisions in the 1999 editions, with the additional paragraph saying that if you don't file your notice within the 28 days, then you will lose all rights for extension of time, etc., etc. It was just time and money at that stage in the contract. They've changed it since then. Again, for me, it's a really extreme approach. FIDIC considered that it's very good for project management. And it seems to have gone down reasonably well, because in the new editions of FIDIC, these provisions are there unchanged in terms of the 28 days and the sanction. In fact, they've extended it not just to contractors' claims, but also to employers' claims, and almost basically any type of claim under a FIDIC-based contract. Again, there's not been that much criticism, and as far as I'm aware, in the common law world, nobody has really said these are invalid if the applicable law is, say, English law. So what about the civil law world? Again, the only contract that I've found is the one I mentioned before, the World Bank contract for civil, which is for civil works. There are almost no notification provisions. The idea of a time bar is something which is really beyond French contracting practice, international or domestic. It's just not something you find, at least in France. And I think that to some extent is the case in a lot of other civil law countries. And if you look at it in the context as well of the claims provisions under FIDIC now and under the others, World Bank have now adopted a lot of the FIDIC provisions, and you've got 5 to 6 pages of detailed stipulations as to how to file a notice, what a notice is, how to do the claim, etc., etc. The civil law contract, all of that is in less than half a page. Completely different approach. And to some extent, it's not cause and effect, but to some extent, this is mirrored in the whole attitude to time bar provisions. The English approach, English law approach that I've always lived with is, you know, you are adults, consenting adults. If you agree to this in the contract, that's it. You didn't file your notice in 28 days, hard luck. You should have had professionals on your team, contract management team, to do all of this. And so that is, again, perhaps I'm oversimplifying, but that is basically the provision in English law at the very least. In the civil law countries, as I was saying, you don't find this in the contracts. And then the question is, well, there are contracts where there are disputes under civil law. Of course, there are loads of them. But unfortunately, none of these have resulted in disputes on this point in the state courts, especially not in the French courts. So they haven't dealt with it. And there are not that many arbitration awards that get published, even partially, dealing with this sort of issue. And I've really not found anything, unfortunately. I was hoping to have something to say to you today, but there really isn't very much. So what I have to go back to is the views of French doctrinal writers really on this. The French courts haven't dealt with this. Obviously, there's nothing in French legislation. There's a general view, I would say, a consensus among the French legal writers that, you know, we have a general principle, pacta sunt servanda, contract terms must be followed. Fine. And that these provisions are valid if they are reasonable in the circumstances, whatever that means. But the position is, for me, is far from clear. There's plenty of room to argue it, especially if you're counsel for the contractor. Because remember, under French law, under civil law systems, there is another mandatory rule, which is that contracts must be negotiated and performed in good faith. And an aspect of good faith is that the contract terms must not be applied abusively. And so that may well have a big impact upon the applicability and the validity of these provisions under French law. Unfortunately, the international case law is not like Indian construction case law. There's not enough of it yet. So I can't really go very much further for the moment. Thank you.
Yeah, thank you, David. So I think this topic was also came up during yesterday's sessions, and it was discussed and debated. And finally, what was coming out was there is a huge difference between common law and civil law position, especially English law and civil law. Let's say in Middle East, and Middle East position is just claim never dies. Now, at this stage, Mr. Singh, what is Indian position? Let's say if a contractor does not submit its extension of time application within those strict provisions of contract, how does Indian law deals with that situation?
I would say that 28, the number 28 is the key. Like David was talking about 28 days requirements under FIDIC suits of contract. Here we have section 28 under Indian Contract Act, which basically deals with such issues. And so therefore, in order to appreciate this topic, one has to understand section 27 of Indian Contract Act. And if you have to understand section 27 of Indian Contract Act, one has to really see the origin and history of rather section 28. This section 28 was amended in 1997. Prior to 1997, section 28 as it stood was that it created distinction between extinguishment of a right and remedy. So section 28 prior to 1997 said that by contract, you can extinguish rights and such contractual stipulations would be enforceable. However, you could not extinguish the remedy. In other words, you could not extinguish the remedy for a party to go to court or to the arbitration. This was pre-97 situation. Clauses which used to extinguish the rights, those clauses were enforceable, but clauses which were extinguishing the remedy, that was not enforceable, it was void. In 1997, in section 28 of Indian Contract Act, the clause B was added. The pre-amendment position was retained as it is, and B was added. And the effect of that is that now, not only you cannot extinguish the remedy by contract, now you cannot even extinguish the rights by contract. Result therefore is whether your contractual stipulation is extinguishing the right or the remedy, both are void. And this is the situation in Indian position. And for that, one judgment, I'll refer to only one judgment of Indian Supreme Court, that is of Justice Nariman, that is Union of India versus Indo-Sind Bank, that is 2016, volume 9, SCC 720. It deals with this. Now, question is whether it is a good prescription. Answer is yes and no, both. Yes, because it avoids injustice to the consumers who are dealing with big corporations, and it applies across the board, irrespective of the nature of the contract. That is the reason for yes. And if you ask me no, it is problematic for commercial and construction contracts. Contemporaneous submission of documents, contemporaneous decision of issues and disputes are always take you to the real justice, real proper decision making. In fact, Supreme Court for the pre-1990 situation scenario in the National Insurance Company Limited versus Sujir Ganesh had said that if claims are preferred with promptitude, they can be easily verified and settled. But if it is other way around, we do not think it would be possible for the insurer to verify the same, since evidence may not be fully and completely available. Very valid reason, but we had 1997 amendment and it dilutes the whole position. Now, so yes and no, these are the yes and no situation. And if you ask me to offer any solution, I would say there are two solutions. One solution is that obviously solution can come either through judicial pronouncements or through legislative intervention. There are two solutions I can offer. One is to adopt the English approach, which David was talking about. If there is a specific wording which two contractually competent parties have entered into, then treat such periods or notice period as a condition precedent to the claim. Then a contractor loses its right to claim if he doesn't comply with the precondition, full stop. And then you have multiple judgments of English courts. In fact, Obrascon judgment of 2014 is again interesting judgment on this. So that is one. You follow simply English in this position. Second solution can be that you draw analogy from other sub areas of contract law. Like in certain situations, like in the cases of coercion, if there are two entities who are talking, two set of entities who are claiming coercion, the party who was vulnerable, was not having proper bargaining power, was otherwise having incapacities of various other nature. They are treated differently than the party who was the commercial party and is ready to bargain with eyes and ears open with proper legal advice. So we can have differential approach where commercial and construction contracts can be dealt differently from consumer contracts. So my suggestion would be, for commercial and construction contracts, you can have a precondition as precondition. Notice periods should be taken as precondition, which should not be the case with consumer contracts where you have a vulnerable section of society who are vulnerable for exploitation. So that is what I have to offer. Thank you very much.
Thank you, Mr. Singh. Now, just before we move to another small topic on liquidated damages, let me just explain to the viewers that in case you are submitting your extension of time application, it is important that you establish that there is a critical delay caused by the employer or the engineer, and that is done through delay analysis. And there are two different high-level formats of delay analysis: a prospective delay analysis and a retrospective delay analysis. A retrospective delay analysis has also got several different types under it, like as planned, as built, but for analysis, while prospective analysis is time impact analysis and impacted as planned method of analysis, etc. And all these are specified in two important guidelines. One is the Society of Construction or Delay Protocol and the American Association of Cost Engineers recommended practice on delay analysis, both of which are available on the internet free of charges. Now, as part of this, analysis, you will be able to establish that what is the extent of concurrency. Like Mr. Singh said, the compensable delays, concurrency plays an important role. That what is the meaning of concurrency? Employer says, contractor, you caused the delay. Contractor says, employer, you caused the delay. So a situation of concurrency is there. Now, it is important to understand that, again, a situation of concurrent delay only comes when both the employer and contractor alleged delay events are critical. So the first and foremost is criticality of the delay event has to be there. Then only it has to come into the bracket of concurrency. And then by way of a concurrency analysis, a delay expert can easily identify what is the extent of concurrent delay, what is the extent of non-concurrent delay. At this stage, David, to you, how do you establish in international arbitrations a delay claim? And do you have any idea or opinion which you would like to share with the viewers related to this controversial or a complex issue of concurrency?
Two things. I'll have to keep it very short because time is a bit
Yeah.
short. The second one first, on concurrency, be careful. Underlying law. I think concurrency is not like liquidated damages and penalty clauses. The judge of the disputes will respect what the parties have put in the contract. I don't think there's anything mandatory there. But you need to be pretty clear, because English law is different from French law in it. The English law is basically as set out in the latest edition of the SCL protocol, 2017. The French law position is different. Would you believe it? Scottish law is also different from English law, and it's closer to French law. So there is you've got to set things out very clearly in the contract as to what you want to do. And you started to mention there, Rohit, the various ways of analyzing the delays to try to work out what the entitlement might be. And we're getting into what some people call the dark arts of time impact analysis, etc. I think it's very important to be clear as possible so you don't have a dispute about process. You've got to have enough disputes about entitlement. But come back to what my first observation is, which is really saying the obvious. Don't wait until the arbitration to prepare the claim. You are looking for trouble. And proper contract, proper principles of project management, good principles of project management and contract terms, such as the FIDIC ones, don't really give you that much of a choice to do it. If you want to have a valid claim, you've got to really do things up front. Yes, I think, as Rashmi was saying earlier on, owners might want to put the discussion off to the end, but contractors can't do that. They've got to do the maximum up front. That is the best way to develop their entitlement. And they've got to take into account things such as mitigation, which have to be dealt with up front. And if there's any possibility of acceleration measures that might be applied, these things have to be decided up front. So do things as soon as possible. And this is not just the wisdom of David Brown. This is, and this is what I mentioned earlier on, this is core principle number 4 of the SCL protocol. Just the title. Do not wait and see regarding impact of delay events. Right. It's all there. I'd love to read it out, but we haven't got time. Page 23 onwards, two pages, which really explain how you should do all of this. Thanks very much.
Thank you, David. Now at this stage, Mr. Singh, again, I'll request for a quick answer. How does Indian law deals with a concurrent delay? Like, my understanding is under English law, if there is a concurrent delay, you get extension of time, no cost. Under the civil law, there is an apportionment approach where, partly based on the dominant delay events, partly, prolongation costs are given under civil law, and especially I'm talking about the Middle Eastern laws. What is the position of Indian law related to concurrent delays?
Thank you, Rohit. Before we deal with the treatment given to concurrent delay, I would say that one must understand what is concurrent delay. I know there are various definitions which have been offered for concurrent delay. And sometimes it is said that it is very difficult to define find out the concurrent delay, which is really goes closer to the theoretical definition. But broadly speaking, generally speaking, concurrent delay situation is where 2 or more events occurring within the same time period and each independently affecting the completion date. So you have delays by the culpable delays or delays by the employer as well as the contractor, which delays are happening at the same time, and which both of which have the effect of delaying the completion date. That is broadly the definition of concurrent delay. And this is where I would say I'm reminded of the famous lecture of Lord Thomas, 2016 lecture of the then Chief Justice of UK, where he said that the entire subject matter of cases which used to be heard by courts are now being heard by arbitrators. And he had said that how arbitration is really coming in the way of evolution of common law principles. Same is the situation here. In India, virtually we have no Indian case law on concurrent delay. That is the starting point. There was never a situation where courts were really confronted with, or courts had the opportunity to go into this aspect of concurrent delay and deal with the positions which are prevalent in other parts of the world. Only one situation, there is one judgment. In fact, the same is Madras High Court of this is the Secretary of Government Tamil Nadu, TN, Secretary of Government TN versus SPL Infrastructure. This is 2000, pronounced in 2019. This is one judgment which again does not go into many details, because there was no need to go into those details in that particular factual circumstances of the case. But if you read that judgment, you will find that there is a subtle reading. If you see this judgment, it favors the malmation approach, which is the very favored approach in common law jurisdictions, and which is the leading approach under English law as well, which provides that in case of concurrent delay, contractor is entitled to EOT but cannot claim prolongation costs. So that is what malmation approach is, and this is what that judgment, while referring to malmation approach, talked about. Again, as David said, SCL protocol also favors this position, though we have multiple judgments, very well-written judgments by UK courts, which was Walter Lilly, you had Henry Burt and all, and which and what David was saying, that ultimately now the North Midland says that ultimately it is for the parties to decide. Whatever parties have decided, courts have to go by that. But question is, what if parties have not decided? Yeah. Then you go to a SCL protocol or the malmation approach. There is another interesting thing which happened. There are two approaches which you see again. These are the situations where arbitral tribunal dealt with. I must say this, in our India, before the arbitration tribunals, lawyers are going with the English position and all the judgments, and they are dealing with them. So lot is happening within in the arbitration space, but somehow it is not going before the court. It has not gone before the court so far, where court would have had any opportunity to deal with this situation. Now, there are two more positions which appears to have been taken by courts, again in arbitration while dealing with arbitral award. One is this judgment is NHAI versus RN Sethi. This is Delhi High Court judgment, 2014 judgment, NHAI versus RN Sethi, where what had happened was the arbitrator noted that there was some delay on the part of the contractor as well. But arbitrator said that the governing delay was on the part of the employer. And therefore, contractor was entitled for entire extension of time for the entire period and prolongation cost accordingly. Now, this issue was discussed, and court upheld this position taken by the arbitrator. Please appreciate, courts have very limited jurisdiction and supervisory role while entertaining applications under Section 34 of the Act. Or in other words, while dealing with the challenges to award, courts have very limited jurisdiction and limited role. Therefore, it cannot be taken as something which is really the finding of the courts after detailed analysis of the positions or the arguments of both sides. So this is one. Another there is one or two judgments, again of Delhi High Court, where the courts, while dealing with such situations, in one line would say that these kind of concurrent delay situations, without expressly saying that concurrent, without using the expression concurrent delay, they would say employer has delayed, contractor has delayed. Therefore, they say it is a case of contributory breach. And then they stop there. I would like to add a few words to what Rohit was saying. Most of the problems which we see in India in prolongation cost claim, prolongation claim, or claim for extension of time is unawareness about the role of delay analysts amongst most of the employers and contractors. Whenever you have EOT claims being led, or after the disputes have arisen, you have arbitration going on and you have to do the delay analysis. This is not something everybody can do just because somebody is engineer, somebody is a lawyer, somebody. No, this is something, an area of it requires real expertise. And now, fortunately, earlier we used to call experts, delay experts and quantum experts from abroad, which used to be very, very costly, sometimes prohibitive. Now we have organization like Machine. They are very competent set of people and they are providing all kinds of delay analysis services and quantum services. Now, difficulty is this, please appreciate. Invariably, in every construction arbitration, there is no delay analysis. Even in-house, people have not done proper delay analysis, even for claiming extension of time. Now, when you are raising extension of time claim, you are not doing delay analysis. You are not considering the critical path. You are not seeing what was your baseline program, how it has evolved, where is problem lying. Now, you are not doing any delay analysis. You are not talking about whether delay is on the critical path or not, whether there is any float, how to deal with this, whether there is concurrency or not, how to deal with this, whether there is neutral event or not, how to deal with this. Now, so one thing is that contractor is not doing a job. Generally, again, proper documentation, lack of proper documentation, awareness about maintaining proper documentation is yet another challenge and aspect which everybody should keep in mind. Now, when such claims, delay, the EOT claims are going to the employer, employers are invariably again not doing delay analysis to confirm whether delay analysis done for the EOT is correctly done or not. End of the day, what happens? You have emails but sent by one party, or EOT asks for 100 days. Employer either gives you 10 days or say, we will deal with this letter, provisional extension of time. All of this, and David was rightly pointing out, even SCL protocol says, never sit over the claims raised for EOT. This is one of the areas which really creates problem, which is unless you deal with this then and there contemporaneously, you are inviting disputes. And so this is one area. Again, what happens? End of the day, matter reaches the arbitration tribunal. Invariably, the tribunal members are not, and in any case, even tribunal members are engineers. That does not mean that they would really be in a position to decipher the entire schedule to understand how delay happened, when delay happened, what were the critical activities, when critical activities, which non-critical activity became critical activity, how everything has traveled, where exactly was the problem, how float is being taken care of. All of this requires expertise. We need experts for that. Now, what is happening? You have just emails written by both sides to each other saying, I have not delayed, you have delayed. And I must say, I have not come across a situation.
Mr. Singh, you are on mute. Yeah, now it's
audible now.
yeah. So just for a minute.
I sit as a chairman, I sit as wing arbitrator, I sit as sole arbitrator. Invariably, what we see for entire delay, even it is for 4 years, one side says entire delay is attributable to the employer, employer says entire 4 years delay is attributable to the contractor. Now, what will arbitrators do? None of the sides have done delay analysis. What is being brought before the arbitrator is letters written by parties or the engineers, project engineers or lawyers. So what arbitrators do? They have no means. They are also not appointing experts, tribunal appointed experts. They are not themselves experts. They may be expert in a sense that they are engineers or architects, but question is whether they know how delay analysis is done. If that is not the case, what you end up doing is you are splitting the baby, rough guesswork, which takes us nowhere. Very recently, in one multi-billion thermal power claim, I was cross-examining one expert on delay, and I cross-examined for 12 days on just the methodology adopted. I understood, for me, the methodology adopted, which was asked by the tribunal to be adopted, was APAB, as David was saying, and Rohit was also saying, Society of Construction Law prescribes different methodologies. I said the methodology which is being claimed to have been adopted for delay analysis was not the right approach which has been taken by the delay expert, and I was cross-examined for 12 days. I said it is a mix of two methods. It's not one method. You are referring to AAC guidelines of USA. Even that has not been done. So question today is we need more discipline, proper record keeping, and we need proper delay analysis if you want to really have proper answer and solution to the delay claims and prolongation claims.
Thank you, Mr. Singh. Thank you. And I fully agree, Indian arbitration scenario have to change. But thanks a lot. I think we have crossed our time limits. And at this stage, I would like to end the session. We had a lot of more discussion to be done. But, the topic of delay is always an interesting topic. And honestly, if I get into the shoes of concurrency, then it's it's itself is a concept which takes a lot of time, dominant concept, non-dominant concepts of delay and all. But at this stage, I'd like to end the session, and I'm really grateful to all the panelists, Rashmi, David, and Mr. Singh, for taking out time. I'm really thankful to the audience. I believe, the symposium organized by us has been a super success. We had almost 4,700 people attending the symposium. We have got emails where we have got questions, almost close to around 1,700 questions have come, and we as Mason, along with the panelists, will try if we can answer those questions separately on the email. But I'm really thankful to all the attendees and to the panelists, and thanks a lot, and good afternoon, everyone. Thank you.
Thank you very much.
Thank you. Thank you. Bye-bye.